Welcome once again to Lehto's Law. Here's Steve Lehto.
For the last 24 hours, my inbox and the email's been getting pummeled by people saying, Steve, you've got to do this story. Now, I've done a similar story to this once or twice before, but this is an interesting one simply because of the scale of it. But also, I had several people say, but it's political. You might not be able to do it. The politics doesn't matter. We'll remove the politics almost instantly. But we talked before about attorneys who use AI to draft briefs for them and then submit them to the court without double checking to make sure everything in the brief is on the up and up. And so I'm going to say something out loud right now, which is going to send a shiver down the spines of many attorneys in the audience, but Rule 11. If you are in federal court and you file a document that runs afoul of Rule 11, the words Rule 11 are often followed by the word sanctions. Rule 11, sanctions. You don't ever want to have a judge say, I believe you violated Rule 11. So we're going to talk about Rule 11 in a moment. But first, from the National Law Review, Andrew R. Lee wrote this: Court slams lawyers for AI-generated fake citations. A federal judge in Colorado has issued a scathing order that should serve as a wake-up call for attorneys who use generative AI models in legal research. On April 23rd, a federal judge of the District of Colorado issued an order to show cause in Coomer versus Lindell that exposes the dangers of unverified AI use in litigation, particularly in federal court. Now, one sentence here to explain the politics of it. The defamation lawsuit involves a plaintiff who's a former Dominion Voting Systems executive and defendant Mike Lindell, who is famous for being the CEO of MyPillow. The case has gained significant attention, not only for the high-profile parties involved, but also for becoming a neon red blinking cautionary tale of consequential generative AI misuse. So I'm not going to mention the politics again. It's not necessary. You got two litigants in court. One entity is suing another entity, and they're doing this in federal court. And then one party filed a brief, which the judge said contained nearly 30 defective citations in a brief submitted by the defense attorneys, and they weren't mere minor errors. 30 defective citations. You have to understand something. When I cite a case, okay, and any attorney cites a case, there's a case name. You've heard of these case names: Ayer versus Ford, Roe versus Wade, okay? That's the case name. Then it's followed by a citation so someone can look it up. And then it'll often have a page number saying, when you're looking at the case, just look at this page and you'll find this quote. Turns out that many of the citations were to cases that literally do not exist. They're totally imaginary. There are also legal principles attributed to decisions that contain no such language. And this is something that anybody who practices in a particular field of law would know, what the leading cases are. When someone comes along and goes, oh, there's this case over here that says this. And people in the field are going, wait, what? Huh? You go look up that case and it doesn't say that. That's a problem also. There are also cases from one jurisdiction falsely labeled as being from another. We've talked about this before. There's the federal districts, okay, and then they're in circuits. And so case law from your circuit is binding in your circuit. It's not binding in other circuits. And so it matters very, very much where, which circuit your case came from. And then there are misquotes of actual legal authorities. So they would cite a legal authority and then put something in quotes that did not come from that legal authority. So one particularly egregious example involves a citation to Perkins versus Fed Fruit and Produce Company, 945 F 3rd 1242, page 1251, 10th Circuit, 2019. That case completely made up. The court noted that while a similar named case exists in a different form, the generative AI tool had essentially cobbled together a fictional citation by merging elements from entirely different cases. Now, when confronted about these errors at a hearing, the attorney who filed these pleadings initially deflected, suggesting it was a draft pleading. It was a draft pleading, or blaming a colleague for failing to perform citation checks. Only when directly asked by the judge whether AI had generated the content did the attorney admit to using AI. Even more damning, The attorney admitted that he failed to cite check the authority in the opposition after such use before filing it with the court, despite understanding his obligations under Rule 11. The court expressed open skepticism about his claim that he had personally drafted the brief before using AI, noting the pervasiveness of the errors. And here's the thing. Let's back up a split second here. If you said, Steve, did you know that you filed a brief with a court that contained 30 defective citations? I don't know if I'd sit there and start tap dancing, No, the dog ate my homework. I don't know. AI verification isn't optional. It's a professional obligation. And this is Andrew R. Lee now speaking, okay? And he's saying AI verification is a professional obligation. So if you use this tool, and by the way, no one's saying that you can't use the tool. You can use the tool, but understand that it occasionally makes up stuff. So you've got to double check everything in it, citations and all, okay? Extremely important. While AI tools can enhance efficiency, they require human oversight. Now, somewhere down the road, they might not. But as of right now, yes, they need a babysitter. The ethical foundations of legal practice remain unchanged. Attorneys must verify information presented to the court regardless of its source. And when he's saying they must do it, they're doing that under the potential penalty of them Rule 11 sanctions we're going to talk about in a second. So as generative AI continues to integrate into legal practice rapidly, this case serves as a stark reminder that technology cannot replace professional judgment. Case citations must be verified, quotations must be confirmed, and legal principles must be substantiated against primary sources. While the legal profession has always adapted to new technologies, core professional responsibilities have not changed significantly. In the AI era, obligations require vigilance more now than ever. Not until this court asked the attorney directly whether the brief was the product of generative artificial intelligence did the attorney admit that he did, in fact, use generative artificial intelligence. And again, you can use it, but you can't rely on it as heavily as you think you might. And so don't get me wrong. There are attorneys who work in big law firms, senior partners. They get the corner offices with the door closed, okay? And so they call in some underling and they say, hey, we need a brief on this point and it's due next week. How soon can you get me a rough draft? And then this person skedaddles down to the law library, figuratively speaking, and starts working on a brief and then brings up a draft of a brief and the senior partner glances it, double checks it, okay, good. And they're so used to doing that when somebody does it with the AI, they glance at it and goes, oh, that reads pretty good. Because the senior partner in the corner office is not normally going, gee, I wonder if this guy made this stuff up. Should I check everything in it? AI, yes. Junior partner, no. Okay, so Rule 11, and by the way, most state courts have a parallel to this, but in federal court, it's taken very, very seriously. Rule 11 talks about signing pleadings, motions, and other papers, and representations to the court. First of all, it goes signature. Every pleading, written motion, and other paper must be signed by at least one attorney of record in the attorney's name or by a party personally if the party is unrepresented. And then it talks about what needs to be there along with your address, phone number. Court must strike an unsigned paper unless the omission is promptly corrected after being called to attorney's or party's attention. So you accidentally file an unsigned paper? That's not signed. You can sign it, but if it's not signed and doesn't get signed, the court can toss it. B, representations to the court. By presenting to the court a pleading, written motion, or other paper, whether by signing, filing, submitting, or later advocating it, an attorney or unrepresented party certifies that the best of the person's knowledge, information, and belief formed after an inquiry reasonable under the circumstances. 1, it is not being presented for any improper purpose. Okay? And there's some more there, but we don't need that now. 2, the claims, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument to extend, modify, or reverse existing law, or to establish new law. And 3, factual contentions have evidentiary support. And 4, denials likewise have some support. But let's get back to 2, because that's the important one. The claims, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law, or for establishing new law. And so here, the arguments are, here's this case law that supports our position. So they're saying this is all existing law, when it's not. And that signature represented the court that the document doesn't do those things, okay? That it doesn't misrepresent those things. And so the interesting thing is, and I'm just being honest here, in 34 years of practicing law in the state of Michigan, I've seen attorneys get up in court, primarily in state courts. That's where most of my practice is. But I've been in federal court. I'm licensed there. But I've seen an attorney stand up and say, Your Honor, we're arguing this. And I've seen a judge go, is that the current state of the law? Or are you asking to modify existing law? And I've seen someone go, no, that's the current state of the law, when it's not. And attorneys in any particular field will often know what the controlling case law is at that time. You're allowed to come into court and say, Your Honor, we think the existing case law is wrong. But you're supposed to be able to identify that to the court and say, Your Honor, existing case law says this. However, we think that it should have been interpreted this way based on the way the statute reads. You're allowed to make the argument, but that's how you're supposed to make it. But you don't go in front of the court and say, this is existing case law, when the existing case law is actually over there. And I know this might sound kind of difficult to understand or follow out of context. But for instance, if you have a statute that says substantial, okay? So it says that something must happen and be substantial. What the definition is of substantial in that field would probably be established by case law. So you find cases that talk about what it is. If they go your way, you cite them. If they don't go your way, you say, okay, here's why we think the court should go a different direction on this. And we are asking for the court to ignore existing case law. But here, you've got a situation where a brief is presented to the court, and among the citations are 30 that have defects in them, including to cases that don't exist, legal principles attributed to decisions that contain no such language, cases from one jurisdiction falsely labeled as being from another, and again, are they doing that to make it look like there's more case law here when there isn't? And misquotes of actual legal authorities. And so we all know what happened here. Somebody under the gun had to draft something, and they asked AI to do it, and AI kicked back this brief that if you read it, you're like, this is a brilliant brief. This is a good brief. This is a winning brief. But when you're reading a brief that contains citations and it has a block quote, and it goes, this is what this court said about this issue, and there's a block quote, and you're reading, you go, wow, and that's from our circuit too. That would be compelling, right? Until you realize that the case doesn't exist, the block quote is made up. And this is the kind of thing that before AI existed, I'm sure it happened, but I don't think I've ever heard of an attorney inventing a case because it's so easy to figure out. So when somebody says there's a case called Perkins versus Fed Fruit and Produce Company, it's a federal case, 945 F 3rd 1242. You can look it up in about 30 seconds on the internet now. In the old days, you walk over to a law library, pull the book off the shelf, and open it up and find out what is, in fact, at 945 F 3rd 1242. And when it's not Perkins versus Fed Fruit, now you go, wait a second, what? So then you'd have to go to an index and search the name Perkins versus Fed Fruit and see if maybe they got one digit wrong. Instead of 945 F 3rd, it's 945 F 2nd. Or perhaps it's 549 F 3rd. And I have gone through someone's brief before. They cited some cases I didn't recognize. And I've gone and looked them up. Oh, okay, cool. It does say that. But the idea that, and I suspect the other side caught this very quickly because they're going, I've never heard any of this stuff. All this case law out there that goes against us in at least 30 cases? Oh, wait. 30 defective cited cases. That's the problem. So keep in mind that when you're signing a document, and some attorney signed this document, they had to, otherwise the court would have thrown it out. It was signed. And the representation to the court is that it is not being presented for an improper purpose, and the claims, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law. And so you should know that that's Rule 11, A and B that I read to you with subparts 1 through 4. C is sanctions. Sanctions. And so Rule 11 says specifically that the court, when faced with somebody violating Rule 11, the court can award sanctions or order sanctions against the party. And it can be as simple as the court can chastise them and say, don't ever do that again. Or the court might say, you know something, because of your 30 defective citations, my court clerk spent an afternoon going through your brief, finding all the mistakes. You're going to pay for that, literally pay for that. And they're going to turn to the other side and say, counselor, did you and your team spend any time trying to chase down those 30 defective citations? Oh, you did. How many hours do you think you spent on that? And what's your hourly rate? And a court can also order the one side to pay the other side's fees for having to run that stuff down. And I've heard of Rule 11 sanctions that are egregious in an egregious case where a court said, we're going to make you pay their legal fees, and it's going to get expensive. And so that's what, like I said, you get the chill down your spine if you're an attorney and you hear Rule 11. Rule 11. It's don't get me wrong, Rule 56 is a good one. There are rules out there that we know, but Rule 11 is the one that every attorney, especially the ones that practice a lot in federal court, go, ooh, don't even want to think about that one. So it's a crazy case. It's not political. It doesn't have, this could be any attorney. And the point is, I've talked before about attorneys who use the AI things to create and write drafts of briefs for them. And they clean up the briefs without double checking every single citation. And you have to. And the fact that anybody is still doing this blows my mind. This to me is kind of like, really? But then again, look at Hertz. You know, Hertz rental cars. They keep popping up in the news. So apparently there are some groups of people who will never learn, And so apparently there are enough attorneys out there who haven't heard about the hallucinations of AI. So got to be careful, people. Rule 11. National Law Review ran the article. Everyone sent it to me. And Andrew R. Lee wrote it. Great article. Questions or comments, put them below this. Talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Only those who risk going too far can possibly find out how far they can go.